The fight for your right to carry. A Supreme Court showdown. Something huge just happened. The Supreme Court is about to decide whether you can actually use your concealed carry permit, or if it's just a worthless piece of paper. Let me explain what's going on. The case that changes everything. Right now, millions of Americans are living under laws that make no sense. You jump through every hoop. You get your concealed carry permit. You follow every rule. And then what? You still can't legally carry your gun almost anywhere. The Supreme Court is now reviewing a case called Wolford versus Lopez. And this case is massive for anyone living in states like Hawaii, California, New York, New Jersey, and Maryland. Here's what makes this so important. Back in 2023, the Supreme Court ruled 6-3 in a case called New York State Rifle and Pistol Association versus Bruin. They said clearly that Americans have a constitutional right to carry firearms for self-defense outside the home. But did these states listen? No. Instead, they did something shocking. They passed new laws designed to get around that Supreme Court ruling. They basically said, fine, we'll give you permits, but you can't actually use them anywhere. Think about that. You have a right that the Supreme Court confirmed, but states found a loophole to make that right meaningless. What these laws actually do. Let me paint you a picture of how these laws work in real life. You get your concealed carry permit after weeks or months of paperwork, training, and background checks. You think you're good to go. You think you can now protect yourself and your family. But then you step outside. You can't carry at the grocery store. You can't carry at the gas station. You can't carry at restaurants, shopping malls, or parks. You basically can't carry anywhere except maybe walking down an empty sidewalk. Why? Because these states created what they call sensitive places, or used property rules to ban guns almost everywhere. They made your permit useless. Hawaii's law is a perfect example. Their new rule says you cannot carry a gun on any private property unless the owner gives you explicit permission first. And they flipped the whole system backwards. Here's how it used to work throughout American history. You could carry your gun anywhere unless the property owner posted a sign saying, "No guns allowed." That's the traditional American approach. Property owners who didn't want guns on their property could easily say so. But Hawaii and states like California completely reversed this. Now, under their laws, you cannot carry anywhere unless you see a sign that specifically says guns are allowed. The burden shifted from the property owner to you. Do you see the problem? Most businesses don't post any signs at all. So under these new laws, you're breaking the law at 95% of locations, even with your legal permit. That's not protecting Second Amendment rights. That's destroying them while pretending to follow the Supreme Court. The legal battle begins. Gun owners and Second Amendment organizations in Hawaii weren't going to take this lying down. They sued the state immediately. And you know what? They won it first. A lower court judge looked at Hawaii's law and said, "This goes too far." The judge issued something called a preliminary injunction, which temporarily blocked the law from taking effect. That was a victory, but it didn't last. Hawaii appealed to the Ninth Circuit Court of Appeals. And if you know anything about the Ninth Circuit, you know they're not exactly friendly to gun rights. They're known as one of the most liberal circuit courts in America. The Ninth Circuit reviewed Hawaii's law and a similar law in California. And what did they do? They reversed the lower court's decision. They said Hawaii's catch-all property ban was perfectly fine. The gun owners asked the full Ninth Circuit to review that terrible decision. The court refused. They didn't even want to talk about it. So the plaintiffs had only one option left: go to the Supreme Court. The Supreme Court steps in. Here's where things get really interesting. The plaintiffs filed an emergency appeal to the Supreme Court. They said, "We need help now. This law is violating our constitutional rights every single day." Usually, the Supreme Court is very reluctant to take these emergency cases. They typically let things work through the normal appeals process, which can take years. But something changed this time. The Supreme Court agreed to hear the case. And they're hearing it this term, with oral arguments scheduled for January 20th. What made the difference? Two things happened that likely pushed the Supreme Court to act. First, the Trump Department of Justice filed a brief supporting the gun owners. The DOJ called these state concealed carry laws unconstitutional. That's the federal government officially saying these state laws violate the Constitution. Second, 26 states filed a brief together supporting the challenge to Hawaii's law. That's 26 state governments saying, these concealed carry restrictions go too far and need to be struck down. That kind of support from the federal government and from half the states in America sends a powerful message to the Supreme Court. The Trump DOJ goes all in. The Trump administration isn't just filing paperwork and walking away. They're going all in on this case. Attorney General Pam Bondi and the Department of Justice submitted a detailed brief explaining why Hawaii's law violates the Second Amendment. Their argument is straightforward and powerful. They say Hawaii's affirmative consent rule was designed for one purpose only: to suppress concealed carry throughout the state. The law wasn't created to respect property rights or follow the Bruin decision. It was created to frustrate gun rights and expand gun-free zones everywhere. The DOJ points out something crucial. If property owners in Hawaii truly wanted to ban guns from their businesses, they could always do what Americans have done for centuries. Post a sign, put up a notice, say no guns allowed. That's always been an option. Property owners have that right. But Hawaii didn't want to leave it to individual property owners. Hawaii wanted to ban guns everywhere by default and make you prove you have permission at every single location. That's not about property rights. That's about making concealed carry impossible. Now the Trump DOJ has gone even further. They've asked the Supreme Court for permission to participate in the oral arguments on January 20th. They want to stand before the justices and argue directly for striking down this law. That's significant. The federal government is actively fighting these state concealed carry restrictions. Hawaii fights back. Of course, Hawaii isn't giving up without a fight. The state just filed their response brief to the Supreme Court. Hawaii's argument comes down to property rights. They claim their law is perfectly constitutional because the Second Amendment doesn't give you the right to enter someone else's property with a gun if they don't want you there. They say property owners have always had the right to exclude people from their property. And according to Hawaii, nothing in the Second Amendment overrides that fundamental property right. Hawaii argues their law doesn't ban carrying guns. It just requires permission, and that permission can be given verbally, in writing, or through a sign. They claim this fits with founding-era traditions and doesn't violate any constitutional rights. The state frames their law as a reasonable balance. They say they're expanding public carry rights after Bruin while also protecting property owners who don't want guns on their premises. Why Hawaii's argument falls apart. Hawaii's argument sounds reasonable on the surface, but it falls apart when you look at history and reality. Let's start with history. Throughout American history, the presumption was always that you could carry your firearm on private property open to the public unless the owner specifically told you otherwise. That's how it worked for over 200 years. If a store owner didn't want guns in their store, they posted a sign. That was easy, clear, and respected both Second Amendment rights and property rights. Hawaii completely flips that historical understanding upside down. Now you're guilty until proven innocent. You're trespassing with a weapon unless you can prove the owner gave you explicit permission. Hawaii's brief talks constantly about property rights, but they conveniently ignore how property rights have actually worked in America. They ignore that property owners have always had simple, effective ways to exclude guns if they chose to. And here's the real problem with Hawaii's approach. Most businesses don't post any signs at all. They don't care either way. They're not thinking about guns when someone walks in to buy groceries or gas. Under the traditional system, that's fine. Everyone can exercise their rights. Under Hawaii's system, that silence means you're breaking the law. You're committing a crime at ordinary businesses because there's no sign giving you permission. That's not protecting anyone. That's criminalizing normal behavior and making your Second Amendment rights disappear. What happens next? Oral arguments are scheduled for January 20th, 2025. The justices will question both sides, and I predict Hawaii is going to face some very tough questions. The justices who care about the Constitution and its original meaning are going to ask Hawaii, why should we flip over 200 years of American tradition? Why should we presume guns are prohibited instead of presuming they're allowed unless prohibited? Hawaii won't have good answers to those questions. This case is huge for several reasons. First, it directly affects millions of Americans living in states with these restrictive laws. A victory would restore real meaning to concealed carry permits. Second, it gives the Supreme Court another chance to clarify their Bruin decision. The court can explain more clearly how lower courts should analyze Second Amendment cases using the text, history, and tradition tests they established. Third, it sends a message to states that are defying Supreme Court rulings. You can't just ignore the Constitution because you don't like what it says. The bottom line: the Supreme Court is about to decide whether your Second Amendment rights are real or just words on paper. We have the Trump administration fighting for gun rights. We have 26 states supporting this challenge. We have Second Amendment organizations filing briefs and making arguments. But ultimately, it comes down to 9 justices and what they decide the Constitution means. This is one of the most important gun rights cases in years. The decision will impact not just Hawaii, but California, New York, New Jersey, Maryland, and every other state that passed these restrictive laws. Your right to defend yourself and your family hangs in the balance. Stay informed, pay attention, and remember why this matters. The Second Amendment isn't just about guns. It's about whether you have the practical ability to exercise your constitutional rights, or whether states can regulate those rights into non-existence. We'll find out soon what the Supreme Court decides, and that decision will shape American gun rights for generations to come.